Report of the 2017 Marijuana Cultivation Regulation Code Enforcement Program. Mr. Snellings.
Good morning, Chair Lambert, members of the board. Tim Snellings, Development Services Director, and Chris Jellison, Code Enforcement Manager.
Morning.
Beautiful spring day. Great day to start getting your garden in of all kinds, and we're going to talk about one of those here in a moment. You have our written staff report. It has a lot of information in it. I thought what I'd do this time, though, is instead of going through the report, is I want to kind of step back and look and offer some observations about this last year's medical and adult use or non-medical marijuana enforcement program. The first thing is since this was the first year of the personal grow rules from the state of California, the state law, the up to 6 plants per residence, we did spend a lot of time answering questions from the public about how that program fits with our local program. The stay in the box, stick to 6 are part of our messaging. We do spend a pretty significant amount of time answering questions and just educating the public on what the rules are, what you can and can't do in the county. How does the state law connect with local ordinances? And that continues to be an evolving world in Sacramento around the marijuana, the cannabis programs. And I think we'll be getting a report to you, I think it's going to be in May, on that bigger picture of the program. So our focus today is just on our local ordinances, 34A, 34C. Another observation is that our county team works very well together. Development Services, Code Enforcement, Administration, County Council, Public Health, Public Works, General Services, the Sheriff and his staff, and even the District Attorney are team players. And so that's a really great thing.
Even.
Oh. Even? Did I say even out loud? I didn't mean that.
I can't believe you said that with him in the room.
I know.
Careful.
He's always in the room.
I know, really. Oh, boy. With the team approach we take, we've learned that given the nature of the seasonal nature of the program, we can process about 50 to 60 nuisance abatement hearings per year. That's about 10% of the complaints that end up at a nuisance abatement hearing. So we have about 450 to 500 complaints. Most of those come into compliance. About 90% we get compliance one way or another. Actually, sometimes because the season ends and they harvest and we don't quite get to them. But by the end of the year, everybody's in compliance. So about 10% of those end up in nuisance abatement. And so what we have is a pretty balanced team approach. You know, the resources in county council, administration, development services are fairly balanced so that we can facilitate all the work that's necessary to get those to hearing with the hearing officers that we have. So that's what seems to be working well. We also moved those hearings from our office in development services to the court, which was a positive improvement for a variety of reasons, but it's a lot better security in the court than we have in our building. And so that was helpful to have the hearings held at the court. I appreciate the courts offering their facility for us to have the hearings there. Compliance is another part of things. As I look at the program, we achieved pretty high compliance. The 72-hour notice, when we show up on site and they're in violation, we issue the 72-hour notice, and so they have 3 days to comply. If they comply, no penalties, and we go away. And if they don't comply, people have learned, I think, through things like the lien hearings, which you'll be considering at the next item, that it's serious. When you're involved, when a code enforcement officer shows up for a marijuana complaint, it's a serious time in your life, and it's important to give it the attention necessary. And so we've seen pretty high compliance because of the program that we have in place. Another important tool in our tool belt is the helicopter. And first, I was not a real fan of using the helicopter, but as it turns out, the helicopter is a very efficient way to do inspections when you can gather 20 plus inspections in one helicopter flight. That's actually a very efficient way to do inspections, and those are also on properties where we're not allowed access, where we're denied access. So it works from both perspectives. So it has proven to be an effective way through our hearing process as providing evidence of the grow. The other thing is our extra help code enforcement officer approach that we use has also proven effective. So we hire people for the season, essentially, from about May through October for enforcement And it's a very efficient way to run a program. So because there's the expertise out there through retirees, we're able to hire people that have good expertise that we can train for this specific program, and that's been very effective. As far as finances go, you'll hear later, we have about $2 million that were awarded the county via the judgment process. Now, it doesn't mean that we're going to receive all that money. 47 cases were won at hearing, 20 cases were settled to where they have paid full cost recovery and 35% of the penalties. 2 have paid in full, and 18 are on payment plans. That's about $164,000 paid and $128,000 in the payment plan process. And another thing that Chris and Ken from my office was instrumental in making happen was that the, who's the payment plan people with?
Collections.
Collections,
So we
thanks.
partnered up with collections.
Brain.
We partnered up with collections, so the process is now is we'll make the settlement agreement with the party, and then they will sign the agreement in our office, and we'll actually walk them up to the collections department where they present the money to collections counts it, and then they actually get an official receipt from collections, and all the payments go through collections, not our department.
So the cash handling of all of the cash that comes into the department is handled in the place where it should be handled in our treasurer's office. So that's been an improvement to the program as
So
well.
do they call when payments aren't made? Do they make the notice that, hey, listen, this is your next payment's up, it hasn't been made, or whatever? Does collections deal with all of that then? As far as once you give them a certain dollar amount, they go after that, or?
Our process is at the end of the month, we'll receive a list of who's paid and who hasn't. So the people that haven't paid are the ones that we're sending out letters saying, hey, you're a month behind. We offer them a chance to come down and pay it. And if they don't, then that's when we bring it to the board for the lien where they missed a payment.
So they may show up at collections or at our office. If they show up at our office, we walk them up to collections. Either way, the transaction will occur in collections. So it's a very good process. And then lastly, as a reminder, there's 14 final lien hearings that are planned for April 10th, your next board meeting. Hopefully some of those will come in before that meeting and settle. That opportunity is still available to them prior to the board meeting. And with that, I'm going to turn it over to Chris before we turn it over to you for questions and public comment. Chris?
Just to add a couple things to what Tim was saying. So when the officers are out there doing their inspections, the dialogue out there between the growers and the landowners is they know that, the board is looking for them to not grow, and if they grow, to grow in compliance. So the word out there, as far as the settlements, that's how we were out there, and they were able to abate before we got out there. So the word's out there among the growers. So, and also on the public meetings that we've held, we're talking about marijuana, but we also talk about code enforcement issues. So it's a great way for us to get out and not only talk about marijuana, because there's a lot of what we do, but we also talk about abandoned vehicles. We talk about junk in public. We talk about all that other stuff. So it's great public education on that. And then as far as the teamwork, teamwork has been instrumental with the sheriff's department, with the district attorney. Couldn't do it without them. With the county council, couldn't do it without them. The process has been streamlined for our hearings. We had a couple hurdles in the hearings, but we got those ironed out, and it's just such a faster process for us now. And then for us to be up at the courtroom doing them, it's just great for security and safety of our personnel and people that come for the hearings. So.
I think the other thing I'd mention, we're looking forward to the 2018 program being the same program as 2017. So each year it seems like we've had something change in the law with the ballot. And this year, the 2018 program is going to be very much the same as the 2017 program as far as the rules in effect and the program that we intend to implement. So we have a plan. It worked in 2017. We have every expectation that it will work in 2018. So with that, we're ready to answer any questions.
So when you're out doing your inspections, you're looking for other code enforcement issues. At that point, could you look at the experimental wells and see, hey, using a well that's not permitted?
Thank you for that question.
I'm sure you love it.
Not really, but thank
Yeah.
you. Okay. Actually, the primary focus this last year and previous years has been on plant count. And, the focus of, we've been focused on 34A and 34C compliance, which for us has been about getting the plants out of there. What we're going to do is, and we've been having some conversations about the whole issue of exploratory wells, and that I think that through better coordination this next year, we will make better impact on those exploratory wells that have not been completed properly, either destroyed or capped And so we're working with public health on a plan to implement that this coming year. But I would say it hasn't been done as effectively
Because
as
to me, it seems like it'd be a pretty simple process. You just follow the PVC pipe up to the hole, right? Because they're all above the ground. They're not like sophisticated, most of them.
Right.
And you look there and you go, wait a minute. You cut that off because it's not legal to have water coming out of that hole. Hey, those plants go away.
Right. I think we're going to have more conversation about this, but if we're on site, on the ground, certainly if we're in the air, it's a little more difficult.
Yeah, I understand that.
But I think that we can do more, and we plan to do more this year around exploratory wells.
Yeah, because I mean, I think that to me, I've had some rogue heifers lately. They've been traveling through the hillsides, and I've come up on a few places that are farmable, and they all have plastic PVC pipe wells capped off down in them. And I'm like, oh man, I mean, here's a prime example.
Right.
It's not my job to find those out, but I mean, I can,
Right. So typically there'd be a generator connected with that, and then a bunch of pipe.
Solar.
And so it's
solar.
it's all illegal as far as that connection goes to an exploratory well.
And the good thing about the big open terracing, when the cows get out, they go there.
Okay.
So, I can do that.
Yeah.
But a little unnerving for a guy like me pulling up on those to find them up there, but
Right.
I think that, but I think that when you're there, I would think you'd be able to walk in and say, hey, listen, where's the water source coming from?
Yes.
And if you hear a generator running, you probably could figure that out too.
Yes.
Any other questions?
No, you nailed it. I'm good.
Okay. I see a lot of that. Unfortunately, every place I have leased has something right next to it growing, so thank God they subsidize my lease. I've had to pay them more than I do, but I digress quickly. Anyways, any other questions? That was for information only, so.
Yes.
Public, anybody in the public like to? June, come on down.
Hello, Board. This is June from Bangor. I'm just going to read this in the note form that I just made. Okay. It's not a conflict with code enforcement and the planning department if commercial cannabis was legalized. The enforcement actions would be integral and the fines might actually go up or what, and I just think the community ought to be given a chance to come into legal compliance first, especially the people that bought in 2013. All right. So the Prop 64 results for Butte County it was 95,731 people voted, 51,034 yes, 44,697 no. So it's a 6,337 vote difference in yes, 53% yes. Okay. I heard a rumor that Butte County might go bankrupt in 3 years. I don't know if that's true or not. Okay. So I think that they're going to do about like $5 million worth of real estate assets in this chunk, these 15 properties. Let me see, I got my notes. I knew I would do this mixed up. Yeah, so if they seize $5 million worth of property because these people don't pay, and then that's sold at pennies on the dollar at a tax auction, we're going to go bankrupt fast if we're doing that in cycles, seizing $10 million worth of real estate a year, $15 million. I had the average, medium home value in Butte County, $274,000. So 15 properties, that's $4,600,000, So, and they just said they're going to do 13 or 14 more. And, so yeah, I literally think this is going to drive us to bankruptcy. And in the rural community I live in, there's no one out there anymore. And I think the businesses are going to go. All right, yeah, it's like I said, it's not a conflict with code enforcement. It's up to the board to come up with a compromise and change the laws. And I just want to, that's it. And I would like to, let's see, just read this. I want to thank law enforcement officers, first responders, firefighters, and veterans. Thank you.
Thank you. Anybody else would like to speak up on this item?
Hi, my name's Satasha, and I do have what do you guys do when people grow at houses that do not belong to them, that they're squatters, and how do you guys put a lien on something that doesn't belong to them?
Okay. We'll address it after for you. Anybody else like to speak? Have any questions of staff at this point before I close it up? Okay, I'm going to close that portion of it, and can you answer that question for us, Tim?
Sure. The program is focused on the property owner, is the one that's responsible for what occurs on their property. So if they choose to rent it, they're responsible. If for some reason they don't choose to and someone squats on their property, they're still responsible as the property owner.
So does, if somebody does squat on there, and say you're an absentee owner, you're down south or out of the state or whatever, and you don't know that, right? You notify the owner?
Absolutely. So the owner is notified because we post the property. Every process and every step that we go through, we're either posting or we're mailing. So we work with county council as far as title reports to get all the people that have been on the title, that are on the title, and we're required to post and mail all of the notices to them.
So at that point, okay, so they're notified, and those folks are like, okay, hey, I didn't know that was there. Who takes it from there to get them off? Because, you know, I mean, they can't get them off. I mean, they're out of state. Who does that? Does the sheriff come do that because they're trespassing, or
That would be
do
a process where they turn around eviction, basically, so they'd have to go to the sheriff's
But
department.
what if they're not an actual true tenant? They're just, I mean, because some of these properties, I mean, they're kind of remote, and you own them, you've inherited them or whatever.
Yeah.
Who does that?
Yes, Supervisor Lambert. That generally is a process available to all landowners. It's called unlawful detainer. And you basically evict the person from the property. There's a process. You go to court. You prove they shouldn't be there or they've breached their lease. One of the breaches would be they're growing marijuana. And you get a court order, and if they don't leave, the sheriff evicts them.
Okay.
And it's an expedited process. You can do that, because I frankly used to do some in Los Angeles when I practiced there for real estate developers we represented, and it's a 30 to 45-day process if you do it diligently and follow it through.
So if they're in that process, I mean, it coincides with, it's safe enough to where they're not going to get lien maybe too, I mean.
Right. That would be considered working with us to achieve compliance.
Okay.
Absolutely.
Does that answer your question?
No, because the owners were deceased and the house was going through probate.
Are you on this list coming down?
Yeah.
We'll talk about you when we get down there, but that, okay. Any other questions of staff at this time? Okay.
Just like to say, my call volume is down tremendously from previous years, and it seems that what you're doing is working, so keep up the good work.
Yeah.
Thank you, sir.
Yeah, and I think, I just because I happen to know some of those growers around me, they actually kind of like dealing with your officers and stuff. They said, you know, they don't have any hard feelings, and then they're trying to stay within their little, 6 plants or the box and the 6 plants, which I think is asinine, but that's about it.
And we like working with them, too.
Yeah, so good. So thank you.
I would just add one quick comment, which most of the board members are very aware of, because we had conversations about it for a long, long time when we introduced and passed the ordinances. Absentee landlords, renters on property has always been a major problem, and we addressed that after lots of discussion and lots of comment from people in our ordinance, and I think we have a pretty fair, good set of rules that deal with that. Again, it was a major loophole that we plugged. Otherwise, the program would probably be mainly unenforceable if we had absentee landlords who always said, I didn't know what was going on, and yet their property is being used to grow copious amounts of marijuana, and at that point, our hands can't be tied. We need to proceed.
It's too bad we can't send that letter to the federal government. There's a lot growing on the federal ground. We could probably make some money there.
You know, there are other options. I think what we have done with our ordinance is very reasonable and within the bounds of due process and notice. And I know we keep hearing complaints about this, but landlords have a certain amount of responsibility also and a certain amount of due diligence when you own property. And I think most people are aware who own property, especially in the foothills, that marijuana growing in that area is rampant.
Okay, well, thank you. We have a timed item on 5.04, itemized costs and penalties related to nuisance abatement to record a lien and impose a special assessment. We have several of these. We'll start off with letter A. Brad, are you taking care of this, or Chris? Okay.
Good morning, Chairman Lambert, members of the board. Chris Jellison, Code Enforcement Manager, along with Brad Stevens, County Counsel. Please bear with me, my allergies are killing me right now. So, I have today for you a set of proposed liens. These liens are going to start from largest and go to smallest. So today I have 13 for you. We will begin with 11228 Dawn Terrace Drive. The APN is 058-260-060. Code enforcement case number is 17-0359. And I'll just read through these, the chapters first time, and then everything else will just be pictures. So, Butte County Code Chapters 34A and 34C authorizes county to abate public nuisances through hearing procedure and court warrant. County may recover costs and penalties related to abatement by proposing that a lien be recorded against the property and by placing a special assessment on the property. Property owners have an opportunity to pay costs within 15 days of notice and the right to appear before the Board of Supervisors regarding the amount of the proposed lien and special assessment. Recoverable costs. The cost of time and expense in bringing the matter to hearing, the cost of the hearing officer, the cost of any appeals, the cost to obtain an abatement warrant, and the cost to physically abate the nuisance. Recoverable penalties. Penalties awarded at the hearing and the post-hearing penalties. So this first nuisance abatement hearing date was August 8th of 2017. The code violations were Chapter 34A, cultivation area too large for the parcel. As you'll see in the pictures that this parcel was completely covered in marijuana. The parcel had approximately 87,000 square feet of a cultivation area, and it was also in violation of 34C, the number of plants being cultivated greater than authorized. There was approximately 1,569 plants. So I tried to make sure that my officers, when they were out there, they counted every plant. So the abatement warrant executed October 5th, 2017, and we partnered with the Sheriff's Department where we did the abatement warrant, and they came in and they removed the marijuana. This is our only abatement from 2017, the one where the Sheriff's Department went in and took them out. And they took out 1,569 plants. The notice of the proposed lien was sent October 25th, 2017. Non-penalty costs to the county, $13,978, and then the penalties to the county, $75,500, which brings us to a total of $89,478. Here's some pictures. As you can see, the marijuana was all over the parcel. There were some abandoned vehicles. There were a couple hoop houses, which are just the indoor grows covered in plastic. There was a large amount of junk and debris left on the parcel. We have some aerial photos, and we also have ground photos. These are some of the ground photos of some of the junk and debris that was left, and then various chemicals were left all around. And then there's a drying hoop house on the bottom right. These are just more pictures from the ground of the vehicles and the junk and debris. The recommended board action to approve the proposed lien of $75,500 and a special assessment of $13,978.
Is there a house on that residence?
There is not.
Actually, yeah. You see all like the logs laid down, there's all kinds of stuff going on there. Yeah. Okay. Any questions to staff at this time? Okay, at this point, we're going to open up public portion of it. You'd like to speak, ma'am? Come on down.
I'm Sonia Duncan. I'm the property owner. I went to the first hearing, and I understand you guys had 3 days to make your decision. You made your decision in 5 days, so automatically, my understanding is that it should have been thrown out, or however you want to say it, and also because he noticed that he made a mistake, he also sent me a thing for an amendment of only $40,000. So there's a difference in discrepancy in the amount that's owned, that is owed to the county, and I feel that because he didn't make his decision in the allotted amount of time, and he took longer than he should have, that automatically it should have been thrown out, because you can't prosecute or go after me for the same thing, because I understand that's a double jeopardy in the property. I might be wrong, I'm not sure. But I'm just saying that there's a discrepancy in the amount owed on it. Because like I said, you sent me a second notice with the amendment of only owing $40,000, and then the hearing today says that I still owe $89,000. And whatever.
Just let me clear up who he is and what this conversation is?
It sounds like there's some confusion. The hearing was conducted before a hearing officer. I have the hearing officer's decision was Andrew Morrissey. He's an attorney in Chico that sits on our panel. There is a provision in the code that requests that the hearing officer issue their decision within 5 days. Sometimes the hearing officers don't always, put that out right within 5 days, so that may be what she's touching on, but they do it as quickly as they can. The hearing decision was in our favor. He awarded all the penalties that we were seeking. As far as the discrepancy that she's mentioning, I have no knowledge of that.
This is the letter that you sent me saying that you had amended the documents, that you had amended the decision that you had first made, and this is what you guys sent me out on the property, saying that you guys had changed your mind from $89,000 to $40,000.
What you're showing me appears to be the hearing officer's decision. It's the same decision that was issued.
It states right here, $40,000.
Okay, but that was at the time of the hearing?
No, it was not. This was the second letter that I received from the county.
So I guess
Here's the certified letter that you guys sent me and the documents that was in it.
I think what's going on, the hearing was held on August 8th. The hearing officer's decision was on August 25th, I believe, was when he dated his decision. The plants were still in the ground at that point, so the $1,000 a day penalty continued to accrue. If you looked at the information that Chris provided, we had to actually do the abatement with the conjunction with the sheriff's office. So we knew the date certain when the nuisance was abated, when the plants were taken out of the ground. So that was the end date for our calculation for our penalty.
So the 40,000 is if it took them out when you're supposed to, and now we've $1,000 a day.
Correct.
So 30 more days.
Correct.
That's what
The
happened.
pre-hearing cost $40,000, and then the post-hearing cost is $35,000. Yes.
Ma'am, do you understand that?
So in other words, it was after the fact, after the hearing is when you removed it, which is why you're still charging me $89,000, correct?
So the way I understand it is, and correct me if I'm wrong, you had a day to take them out, it was the 40,000, and since you didn't take them out, it was $1,000 a day until you got them, until the sheriff sounded like took them out. So that added up to an extra $30-something thousand for that.
Yes.
So that's, yeah. Do you understand that? I mean, it's kind of like you just didn't take care of business when it was supposed to be taken care of, and you paid for it.
So the people that were on my property, actually, I got taken, is basically how it all boils down, because they
Yeah.
were doing it for a sanctuary, and I got stuck with the bill.
Yeah, that's unfortunate. Anybody else like to speak on this one, this matter here? Okay, I'll close that portion of it and bring it back to the wishes of the board.
Make a motion to approve the lien,
Have a motion, do I have a second?
special assessment.
It's been moved and second, all those in favor?
Aye.
Opposed? Seeing none. Next up is item B, code enforcement case number CE 17-0517-533 Crystal Ranch Road, Feather Falls, AP and 071-270-036.
This proposed lien and special assessment is for 533 Crystal Ranch, Feather Falls. Oh, okay. APN 071-270-036. Code enforcement case number 17-0517. Nuisance abatement hearing date was September 25th, 2017. The code violations, Chapter 34A, cultivation area too large for the parcel size. 34C, cultivation may only take place indoors on parcels less than 5 acres, and the notice of the proposed lien sent was November 3rd, 2017. Non-penalty cost to the county, $5,572.04, and the penalties consisted of $49,500, which brings us to a total of $55,072.04. Here's some aerial photographs. This parcel does have a residence.
What's that in the bottom right picture?
That is junk and debris that was left.
Thank you.
And there were approximately 25,000 square feet of a grow, around 99 plants on this parcel. The recommended board actions approve the proposed lien of $49,500 and a special assessment of $5,572.04.
So just to get this straight, so if they'd done what they were supposed to do when you served them, their penalty would be $5,500?
Well, if they had done what they should have done when they were issued the 72-hour notice, we would never go to hearing, and the county would not seek any cost recovery at all. We put
Okay.
them on notice of the violation, then when the officers re-inspect and it's still in violation, then we notice it for a hearing, and then if we go to the hearing, then we seek an award of penalties.
So the penalties start after the 72 hours, is that right? The $1,000 a day?
Yeah, because they can go back to, I mean, once your time served, right? You can go at that point, once it becomes, hasn't been complied with, you can go back and get your time cost up to that point, right? Is that correct?
Correct. When the 72-hour notice is issued, that's $500 a day, and it's basically an incentive to try to gain compliance. If they're not in compliance when the re-inspections occurred and we're required to notice a hearing, it kicks up to $1,000 a day. So it's $500 during that 72-hour period, then it goes up to $1,000 a day until the abatement, whether it's harvested, whether we go out and remove the plants, or if they choose to remove them before or after the hearing.
I'm always amazed at all the trash. I mean, why? Why so much trash? I mean, it's not that complicated, not to live like that. But anyways, okay. All right, any questions before I open a public hearing? I do have a card on this one. David Kastner? Did I say that right? Come up here, sir.
What it looks like now, that see what happened to Mr. Ferris's place. I don't know if we.
Go to-
They basically destroyed his place. I'm not a very good speaker, but I'll do my best here. I don't know if you got the letter that I sent you showing what he tried to do to stop and get this taken care of. He did try to go through the legal process. I know this gentleman here said that it took only like 45 days to do, but they had a fence up, they had a no trespassing sign. Mr. Ferris tried to get an unlawful detainer, filed 3-day notice. He could never get nothing done. He couldn't afford an attorney. Plus he was going through the process of losing his wife, which was something that none of us like to do or have to do. So I think that you should look at this a little closer. He tried what he could do. That was the main thing. He's not a criminal. He just tried to get done what they wanted him to do, or what you folks wanted him to do. He couldn't do it. He didn't have the money. He only has Social Security. He is now homeless. He rented that property out so that it could subsidize his income, which is very little. The people that he leased to this time obviously knew what they were doing. They knew how to get around the law, because he could never enter the place legally the whole time he was going through all this. So he's willing to pay the $5,572, but as far as putting a lien on a property for the $55,000, he'd never be able to pay it. He can't. He doesn't have the money. So he'll end up losing the property. And I think it's kind of a sad thing that we do to people. I don't think it's right. So.
Sir, did you understand that he leased this out for the growing of marijuana?
Yeah, he did. He did know that. And if he had a way to get into it to see what they're doing, he would have stopped them. He tried. He had the sheriff's department tried to go in there, but they fenced it all off. And then they can put no trespassing signs. He tried to go through the court system to get it done. He has all the documents of what he tried to do, and he never could get anywhere. And legal counsel, he couldn't afford an attorney, so he went to the free legal counsel, and every time he turned around, something wasn't right, or, you know, I mean, he did try to make the attempt to stop them. He didn't know that they were doing what they were doing until they, you know, flew over his place where a complaint was filed. So I mean, he lost a lot. They destroyed the place. As you can see the pictures, they just trashed that place completely. They trashed the mobile. They left garbage everywhere. It's disgusting. So I'd like to see if the board could do something to help him.
So if a landlord has tenants that are growing and he knows he can't do anything after 72 hours, can he call code enforcement and say, I give up, I can't get on the property, I can't abate because they won't let me on the property? Is there any kind of latitude on that? It just seems like he said he tried to get the sheriffs to come.
I met with Mr. Ferris several times, so I advised him of the process all the way through the process.
Okay.
With the amount of cases that we were working, there was a significant amount of time between, you know, the process, so, yeah. But no, we were in contact, we were letting him know what was going on, and, yeah.
But he did make an attempt to try to stop it. I mean, as best he could, or as best as he knew how. So
all I'm just saying, can he say, I don't want the plants on my property, and sheriffs can come and take it off?
I believe Supervisor Lambert asked the gentleman, and he said he actually knew when he leased the property they were going to grow marijuana.
He did. He did know that. No, that is true. He did know it. He didn't know how many they're growing. He thought they were going to do within a law, and obviously they didn't. So, and at that point, he had no idea where to go at that point. I mean, he talked to codes enforcement. He talked to a lot of people trying to figure out what can he do. He'd never run across this before. And
Okay.
Our ordinance does require a tenant to have written approval from the landlord to be able to grow, and if they don't have that written approval, it's one of the grounds that we charge as a violation. And as has been acknowledged here, Mr. Ferris did provide written authorization, but there were, I believe, 99 plants growing on the property. So generally what a lease term is going to say is, yeah, I'll authorize you to grow within the, consistent with federal, state, or county regulations. And if the tenant is out of compliance, like here, grossly out of compliance with 99 plants, that should be grounds to evict the tenant. It's not, you can't get the sheriff to evict the person right off the bat. They do have their due process rights. But as Chris mentioned, our process doesn't occur overnight. Between the time it's noticed and the time it goes to hearing, there's a couple months period as well.
And again, he had no idea that they were out of compliance until they notified him. And the time that it took for him to get everything squared away, plus other things that happened in his life. So,
Thank you.
thank you.
Anybody else like to speak on item B?
Hello.
Hi.
The owner is currently trying to sell the property to get the money to pay, which is admirable. However, he markets the property as a prime grow area.
What's been proven?
This
Sorry.
property has been used for marijuana cultivation, cash only to motivated growers. Price of $65,000 is needed to assure clear title, which was the giveaway right there. So just some further information. Thank you.
Thank you. At least he's trying to. I think, too, it's important to know that on a lien, it's not, it comes out at the end of the sale, right? So, I mean, it's not like if you don't have the money to pay for it at this point, which I understand, that's what the lien process is for. It liens your property, and when you go to sell that, at what point in your life, that's when you get it. So, anybody else like to speak on this item B? Yes, sir.
I am the owner of the property in question. And that ad that you just showed, I have no other way to pay your lien if you're going to assess this lien, which evidently is in the process right now. I was going to sell the property at $65,000. I figured I had money then to cover the lien. Any other charges, any other costs that came up, I could take out of that purchase price. Not making a profit at all for myself on the property by selling it this way, but be able to pay that lien that I feel that you are about to assess right now. Chris Jellison and I did have a lot of meetings, and he kind of advised me on several things. One was, if I were you, I would evict them. Well, I started the eviction process. It's not a 45-day process, and it requires back and forth to Chico, to the county officers there. This whole thing is new to me. I'm not in any way knowledgeable about legal proceedings of any type. My life has been fairly uneventful as far as anything that has to do with the law. I tried my best to do everything that I was either advised by free legal counsel, and as my friend Dave said, I have Social Security. That's my entire income, other than my property that I had up on the mountain. When I leased it, that was a supplement to my Social Security, and I tried to divide that up to add a little bit to my monthly income. The growers paid me nothing, and there was no type of agreement or anything else, as I was kind of asked a couple of times if how much are they going to pay you at the end of their grow period or whatever when they harvest. Nothing. There was no agreement. I didn't know that they were going to grow outside your ordinance. I didn't know that they were going to grow anything more than the legal or the county's number of plants that you allow. On the lease agreement, I did put that they could grow medical marijuana, because a lot of people are doing that. I didn't know how many plants that they wanted to grow. And once they alerted me that this was in non-compliance, that they had flown over, taken pictures from a helicopter, and I saw those pictures, they allowed me to, I had no way to dispute that, yes, there is non-compliance on my property. Yes, there is. I can't dispute it. The pictures show that there is. But I received the payment from the tenants for the full year from April 27th till April 27th of this year. And as far as that lease agreement, because I never was able to complete the eviction by the time that they had already harvested their plants and left. I mean, I have no idea where they are, where they came from, no addresses or anything like that for them. It was just an agreement to lease the property. It had a habitation on there. It had a single-wide mobile home on there. I expected them maybe to live in the mobile home, grow their 6 plants or however many that the county allows, and enjoy the mountain scenery and mountain climate and everything up there. As far as me having any profit or anything else other than the lease of the property, I got no profit out of this. In fact, now, I mean, you're putting me, well, at this point right now, I'm homeless, and this is going to be
So
a big
this didn't cause you to be
imposition.
homeless, though?
Pardon me?
Your homelessness doesn't caused by this, because you haven't been charged anything.
That has nothing to do with what
All right.
happened before. I'm just saying that I am now, and that this assessment is, there's no way I can pay this. So I will lose, not only being homeless now, I will lose the property, which is my only asset in the world, actually, that has any value or had value. So I'm appealing to you to allow me to pay your expenses. I can scrape that amount of money up. But as far as the rest of it, there's no way that I can pay that, and eventually I'll lose the property, I'm certain. But so please just take that into consideration. Think about it. I can't ask you to put yourselves in my position because you would never become in this position probably with your knowledge and all that you have. I didn't have that knowledge, and so here I am.
Thank you.
Thank you for listening to me.
Anybody else like to speak on item B? Hi.
Morning. My name is Charnel James. I am an attorney out of Marysville and have been in front of the board multiple times. I'm actually ashamed to say that I represented the tenants on this property, and what Mr. Ferris is saying is absolutely correct. When the tenants came to me, they brought to me a lease that said that they could grow medical marijuana. They swore to me up and down they were doing it within what their state rights were. We filed a response that what he filed for an eviction was completely incorrect. So it was something that I was able to use the legal tools that are available to help defend defend the tenant from the eviction, especially since they paid the whole amount up in front. Having said that, after the fact, I discovered the extent of their lies, not only to me, but to their own landlord. It's one of the reasons why I've decided not to do a lot of cannabis stuff anymore. I'm doing permitting now, and I've actually closed my law firm because of some tenants like this that have continuously lied to me. Chris can tell you that my staff went up, we did the inspection. When we did the inspection, we discovered how many plants were up there after everything had been removed based on what was up there. I think that this is one of those situations where the landlord was just badly taken advantage of on every side. So I would ask that you use your discretion at this point to waive those fees on his behalf, have him pay the assessment fees as he's requested. He does have a lot of cleanup to do up there. It could provide a home for him so he's not homeless. And I would just ask that you guys use your discretion at this point. Thank you.
Thank you. Anybody else like to speak on B?
So to reiterate, he doesn't have, the fees don't go until the property's sold, so he can live on the property, right?
So let me close the public portion real fast. Anybody else wants to speak on B?
Sorry.
All right, well, jump on up there.
While I was at the planning department, I talked to the person, Ken, who is, some kind of administrator there, and he told me what happens is when you get a lien put on your property, and I don't know if this is totally accurate, but he said if you don't pay the lien in 1 month, it'll be like taken by the county and then sold at tax auction. So that's just what. Okay, am I wrong?
Yeah, you're wrong.
So they had implied things like that.
Yeah, no, you're fine. Okay, anybody else like to speak on B? Okay, seeing none, I will close this portion of it and bring it back. Supervisor Crook, you had a question?
So he doesn't have to pay the lien until the property is sold, is that correct? It's different from a tax lien that actually can be sold by the county?
That's correct. The lien amount, the large amount, is basically a lien on the property. The special assessment will take the form of property taxes, and I believe if it's not sold after, or if it's not paid after 6 years, it could go up for a tax sale.
That's a difference. Okay.
I think Chris had one other item, bit of information on this property to mention.
We did have a 2015 marijuana case on the parcel, and it was closed for end of harvest, so we never actually got a chance to go to the parcel.
So they had the same situation the year before?
Correct.
Okay, so my problem is, you take a risk, you get a cash payment to allow people to grow marijuana in your property, you don't know them, and you get burned. I don't think that's the taxpayer's problem. I look at it, and you got a code enforcement issue now. Somebody's got to go clean that property up. So I'm not very empathetic to people that take gambles and get burned. That's what it was, in my mind.
Any other comment?
Make a motion to approve the lien.
Do I have a second? May I have a second?
Second.
Okay, all those in favor, signify by saying aye.
Aye.
A motion to approve the lien and the special assessment.
Oh,
Okay, I make a motion to approve the lien and the special assessment.
Second.
still second? Okay, all those in favor, signify by saying aye.
Aye.
Okay, any opposed? Seeing none. It's a tragic deal, but it's one that's been going on forever, so.
This is business, and people take risks at business that facilitate illegal activity. They have to pay the price. We've been consistent as a board, and I think we stayed consistent. I thank you for your vote.
Okay, C has been taken care of, so we're down to D, code enforcement case number CE 17-0378, and that's at 690 Fire Camp Road, Orville, with an AP number.
Sir, Lambert, I'm
yes, sir.
sorry.
Yeah.
We actually need to go ahead to number I and pull that one out of order. We have an interpreter that's here.
Oh,
on
okay, great.
I,
Let's do that.
And needs
Okay.
to get back to work.
Okay. All right, so we're going to number I real quickly. It's case number CE 17-1084, and it's located at 45 Hard Rock Road, Orville, AP number 072-560-002.
I'm trying to get there.
That's fine.
Right after? Yeah. That one? Okay.
That is.
Hmm? I saw it. First is
Aye.
But it's not it,
Hey,
maybe.
Bruce. Bruce.
Page is it? Oh, you-
10, I don't have, oh, here?
0820?
It's on 10 on this. Oh, and this thing, I've been line.
L.
It's gonna be L?
Fire Camp Road,
Well,
Ludlam Avenue.
Hard Rock.
right, Hard Rock, but looks like there might be a problem there.
Hard Rock Road. Probably got the wrong address.
Is that gonna be it, Brad, do you think, or?
It's L.
L?
L, yeah.
Okay. Right, so we had a little, we need somebody to be able to, that can interpret. So if you want that, which I think we need,
Casey can do everything anyway.
Are we going out of order or what?
Go ahead and go to the next one that you were going to do, and we'll just...
Thank you, Casey.
all right, so we're gonna stay with I then. Let's, want to do that?
Sure.
You went that far to find the I, that's just,
We already went past
lose
I.
it. What?
Well, that was the I going out the door.
That was L.
L,
We're back to
L.
D.
Oh, that was L.
Who's on first?
690 Fire Camp.
You going to D?
Yes.
What are we gonna do?
D.
D, 690 Fire Camp.
All right.
What is reference?
You're making me look bad. I can't even run this meeting anymore. It's out of control.
There you go.
Go ahead,
So
start.
we're going back to D?
Yes.
That was right to start with then, Brad, just so you know. Let's go with D next. You threw me off.
When I rudely interrupted you,
Yeah, threw me off there. All right, we're going to D. That's case number C 17-0378, and that's at 690 Fire Camp Road in Orville. AP number 072-330-023.
Thank you, Chair. The code enforcement case number 17-0378. The nuisance abatement hearing date was September 5th, 2017. The code violations, Chapter 34A, cultivation area too large for the parcel, and 34C, number of plants being cultivated is greater than authorized. The notice of the proposed lien was sent November 1st, 2017. Non-penalty cost to the county, $3,549.17. The penalties were $32,500 with a total of $36,049.17. Here are the aerial photographs. This one we were unable to get to on the ground. This recommendation of the board action approve the proposed lien of $32,500 and a special assessment of $3,549.17.
Was there a residence here?
There was not. It was a 40-acre parcel. 15,000 square foot grow, around 200 plants.
How are they getting water? It's up on a ridge. Exploratory well.
That's a great question.
It is a good question. The answer is probably exploratory well. I'm just kind of curious. To me, that's a no-brainer. You can kind of figure out how, there's no power up there, really. Okay,
It might be a water truck, too,
yeah,
day and night.
right. Okay. Any questions of staff at this point? All right, I'll open up the public portion of it. Anybody in the audience would like to speak on it, on item D, in case you forgot where we were at? Okay. Yes, ma'am. Come on down. We got to hear you on the mic, because we got a huge fan base that likes to hear all this on TV.
Yeah, we're up to about 20.
My name is Judy, and I live on the famous Craig Access Road. But,
You get out.
pardon me?
Glad you could drive it out today.
Oh, well, I'm not that far in, so I'm very lucky. But could you please include when it was abated and by whom for these cases? That's all I wanted to know.
I don't know if we can do that or not. Can we do that?
The abatement date was August 31st of 2017.
By who?
The grower, harvest.
Forced a little early hand on that one. A little early harvest. Okay, anybody else like to speak on this one before I close it? Okay, we're closing public portion of it, bring it back to the wishes of the board. Any questions or motion?
Make a motion to approve the lien and the special assessment, $32,500 and $3,549.17.
I have a motion, moved and seconded. All those in favor?
Aye.
Any opposed? Thank you. All right, are we going down to L now?
I think we'll just stick with the path we're on.
Wonderful. Next up is E, case number 0529. It's at Crystal Ranch Road, Feather Falls, AP number 071-270-045.
Chair, the code enforcement case number is 17-0529. The nuisance abatement hearing date was September 20th of 2017. The code violations were Chapter 34A, no legal residence, no cultivation area, and Chapter 34C, no legal residence, no cultivation area. The notice of the proposed lien was sent November 3rd, 2017. Non-penalty cost to the county, $4,366.23. Penalties, $55,500 with a total of $59,866.23. This one had a large RV on the parcel, and then there's the grow right there. And there was also a hoop house.
Is that it? That's illegal grading, isn't it? Is that over 50 yards of grading?
Yes, it could be, yes.
This was one of the cases, I believe it was 2014, when our office filed 13 separate grading cases, and this was one of the parcels that we brought a grading action against.
Is this same owners again?
Same owners.
The abatement date on this one was
Must have been business, I guess.
October 25th, 2017.
How many plants? I missed her.
47. 3 separate grow sites.
I thought I recognized it. I hate to say that.
Oh, I'm sorry.
Interesting that the plants and everything are so neat, and then they have a lot of junk. But the grow part is so pretty.
Priorities.
The recommendation to the board action is approve the proposed lien of $55,500 and a special assessment of $4,366.23.
Okay, is there anybody in the public like to speak on letter E? Anybody? Yes, sir.
All I could ask is that if I could make a chance to maybe work a payment plan out to pay these fines, because I didn't get a chance to do that prior to this meeting.
Is that always kind of our option to try to do that beforehand?
Yeah, and I apologize for not taking this into action further before this meeting.
Are you one of the property owners?
I own the property, yes. I'm very surprised she's being this well.
What is our process on that?
Yeah, we can accommodate the owner with the settlement terms. We can, I think, take this off for today and work with him this afternoon, possibly to get that ironed out. If it, for whatever reason, doesn't get worked out, we'll put it back on for the April 10th.
Thank you. I'm
You
willing
have a
to work
comment,
with you
Bruce?
guys.
I was trying to remember our process. Don't we go ahead with the lien, and then we do something else if they enter into a payment plan? So I think you probably should.
We did, last time that we did that, and then
Yeah.
if you got it done before then we took it off.
Right, I
Yes.
think you should finish the item and vote on assessing the lien and the special assessment, and then if the gentleman can enter into an agreement with Development Services, the lien won't go into effect,
Yeah.
unless he then defaults on the terms of the agreement.
Yeah. You understand that? Yeah. Okay.
Fair enough, right?
Yeah, I think that's fair. I mean, the ideal, our goal is not to have us have to deal with this. It can be done before this, but if you come down to the last wire, so, okay, that's, anybody else like to speak on E? Okay, I'll close the public portion and bring it back to the board. May want to make that motion?
Make a motion to apply the non-penalty costs of $4,366.23 and the penalties of $55,500
With the opportunity.
with the opportunity to make a settlement before next month's meeting.
Is that clear? Okay. Been moved and second. All those in favor?
Aye.
Aye.
Any opposed? Okay, thank you. All right. Okay, item F was taken care of already, so that's all. So right on down to G. Case number is 17-0522, and it's at Cochise Drive, Feather Falls, AP number 071-280-038.
The code enforcement case number is 17-0522. The notice of nuisance abatement hearing date, September 20th, 2017. Code violations, Chapter 34A, no legal residence, cultivation not allowed, cultivation area greater than authorized, and Chapter 34C, no legal residence and cultivation not allowed. The notice of the proposed lien was sent October 24th, 2017. Non-penalty cost to the county, $3,373.55. The penalties, $54,500 for a total of $57,873.55. Pictures of the parcel. There was also a large hoop house here.
Now, is hoop houses okay if they have 6 plants in it? No, hoop houses are just bad.
Correct.
Okay. Can you guys bring that hoop house? I didn't know if that was just something.
The recommended board action is approve the proposed lien of $54,500 and a special assessment of $3,373.55. There were approximately 70 plants on this parcel, and the abatement date was October 20th of 2017. So they harvested.
Resident?
No.
Isn't Cochise off of Craig Access? And I remember that road coming up one time, guys on Craig Access. Anyways, I'm sorry. I paid attention. Okay. Anybody like to speak on this item? G?
Hi, Chanel James, appearing for the property owner. We've called and left a message with them about the settlement terms, but I was out for a couple weeks. We played phone tag. I would just ask that this be continued over till the 10th so I can get him into the office to sign the agreement. He already indicated that he was willing to enter into the settlement agreement, so.
So maybe we could do the same thing we just did? Move forward with the lien, but then give you the opportunity to do that.
That would be fine.
Okay?
So they'll have till the 10th to get that signed with them, and
Is that
then.
the date we want to do that, Brad?
Let's do the day before, let's do the 9th, that way we know it's
Yes.
taken care of on the 9th, and if it's not, then it'll go forward on the 10th.
Okay.
Perfect, thank you.
Anybody else like to speak on this one? Okay.
Make a motion to approve the proposed lien of $54,500 and special assessment, $3,373.55, with the option by the 9th, they must have a settlement agreement, and we could revisit it next meeting. Otherwise, the lien stays in place. Is that clear enough? Did I get it right?
You did.
All right.
Stellar. Okay, we got moving second. All those in favor?
Aye.
Opposed? Okay. Next up on it is H. It's case number 17-0698, located at 423 Stage Line Road in Orville. AP number 027-060-061.
The nuisance abatement hearing date was October 11th, 2017. The code violations were violations of cultivation area too large for the parcel. They were allowed 150 square feet, and the cultivation area was approximately 10,000 square feet and around 60 plants. The notice of the proposed lien was sent November 21st, 2017. The non-penalty cost to the county, $2,877.22. Penalties consisted of $49,500 for a total of $52,377.22. Pictures of the parcel, the large outdoor grow, and then there was an adjacent building. And there was a residence with this one. And the abatement date was October 4th of 2017, and like I said, there were around 60 plants.
And they self-abated because they harvested those orange trees.
Those are nice big plants.
They self-abated and they still had those in time, is that right?
They harvested it.
They harvested.
Oh, I see.
Yeah, that's another example of the white pipe you could follow to the exploratory well, just so you guys know. You can see on that one there, you follow the white pipe to where it stops. Oh, I'm cut off already? I had a good speech going there. Okay, anybody else would like to speak on H? Anybody else like to speak on H? Anybody? Okay, seeing none, we'll bring it back to the wishes of the board.
Y'all jump in there.
It's your world.
I'll make a motion to approve the proposed lien of $49,500 and a special assessment of $2,877.22. And do all of these have the opportunity to
Second.
settle before the 9th? Or just the ones that we
No, I think we're just the ones,
I think just the ones that requested, otherwise we'll go ahead and record the lien assessment.
yeah, I think that's a bad pattern, as we already started a bad pattern already.
No, yeah, okay, well, it
I think-
looks like he has an attorney, I wasn't sure.
Okay, it moved in second. All those in favor?
Aye.
Opposed? Thank you. Okay, now we're back to getting to I again. Number 17-1084 at 45 Hard Rock Road, Orville, AP number 072-560-002.
Through the chair, Your Honor.
Yeah.
We are asking that I and J be continued for 30 days before we even present it to the Board of Supervisors. My property owner is here. He has been working with Mr. Jellison. We evicted the tenants, cleared the property, got the inspections done. We've started a civil lawsuit. We have an asset locator locating with the former tenants. We terminated their lease before their lease was up. Tenants did not harvest. We are asking for 30 days for us to complete our default process and get our asset locator so that he can enter into a settlement agreement knowing we have something to go after with the tenants. So we're asking for a brief continuance for I and for item J.
Same landowner?
Same landowner for both of them. Same tenant for both of them.
So what's
I don't understand why it impacts it, why we would want to continue it. I think, has been pointed out, if you approve the lien and special assessment, nothing essentially happens to the property in the short term. If the owner wants to go after the tenants and seek recovery in that manner, it really does not involve the county at that point. So I don't see the need for a continuance in either one.
Your Honor, through the chair, our request for a continuance is based on the fact that we want to still be able to take advantage of the settlement offer that was offered to us. The problem is before we can put out that money on the settlement, we want to make sure that we're able to go after and attach the assets of the tenant. All we're asking for is for a brief period of time for us to continue the legal process, which takes time. It just doesn't move that fast.
So why wasn't it, just done before we get to this point and today?
Well, I was actually involved in the beginning part. I was involved in the eviction, the clearing of the property, the inspection, and the appeal hearing. At that point, I closed my office, and I have been working for another company. Mr. Hassan and I have been exchanging emails back and forth, and he was directly in contact with Mr. Jellison in order to kind of work on and get the settlement. He understands the settlement terms, wants to enter into the agreement. We've filed the lawsuit as was advised. He called me. I've done the work on the side to help him get this stuff done and to clear up this issue with what's going on the property. So he's been adamantly working with the county. We're just asking for a little bit more time.
Okay. All right, that's, that's all you,
That's all I had right
Okay.
before they open the
right.
minutes.
okay. Anybody else like to speak on this one?
Hi, Board. My name is Frank Hassan. I am the property owner. And I just wanted to reemphasize on what she said. I did work from the very beginning with Randall Smith. It was hard for me to find out when the notice was put on there, since my tenants did not communicate that to me. So I ended up finding out afterwards when they were in panic mode. Hey, we got this notice. What can you do? I spoke to Randall Smith, the officer. He advised me, get a lawyer, get them evicted, get them out of there, which is when I called Miss James and basically tried to get everything taken care of that way. Then I flew from Miami to come over here, and I basically abated the property myself out of the trash and all that stuff. But basically, when I got there, the plants were gone. There was nothing there. They left all their trash. Both of my pumps in my well, both properties got damaged. I've had to replace all that stuff too. So there's been a lot of, stuff that I've had to do in order to get back to ordinance as far as picking up the trash and spending money and trying to abide by what you guys, have the law. As far as the tenants, I did have the lease for the tenant, and it did say there that they are allowed to smoke and grow medical marijuana, but they have to abide by California Butte County laws. And that was on my lease as well. So I tried to do everything that I could from the beginning.
Okay.
And I did speak with Chris quite a few times, and he kind of told me to advise me. The next step that I was at right now was basically, get a civil suit against them and try to get them for the money, since they're the ones that were responsible for the grow.
Thank you.
Thank you.
Anybody else would like to speak on this? Okay, before that, I'm going to close it off. Okay, I'm closing the public portion of it. Bring it back to the board for discussion or motion.
So I have a question. Did you see that lease where you restricted them to?
No, I did not. Last time I spoke to Mr. Hassan was on December 21st, and I offered him a settlement.
When was notice mailed and posted?
72-hour notice was posted September 28th and mailed, and the hearing notice was posted October 10th and mailed.
And it was mailed to an address?
All of the subjects on the title, all of Mr. Hassan, the tenants, the growers.
That was his Miami address or his Texas address? Or?
I'd have to look at the case.
It would be the address that he has the property registered with the tax assessor's office. That's what we go off of.
So I would assume he's current on his tax payments, so he's been getting mail.
That would be our hope, yeah.
The abatement date was October 25th prior to the hearing.
I noticed in here in the decision itself, it indicates the notice was also mailed to his attorney, Ms. James.
Well, I can just chirp in real fast. I think it cost of doing business is, I mean, if you can minimize your risk and do the settlement with you guys before it comes today, and then hunt them down later, you're better off. Minimize your risk business-wise. I would have done it before today. Now you have to go hunt them down for more money, type of deal. I think that this is all kind of part of doing business, unfortunately. And you can do everything you can do right. You have rentals. We have rentals. Tenants don't pay. They don't do anything. You have to go through the process, and that's why it's so important to have a good contract and have a good process of doing this. But I think if I knew I was going to be assessed, I would have settled way before today and hunted them down for the whatever it was, 20-something thousand or whatever it was going to be. So that's my 2 cents on that on this.
Well, I would be willing to give them till April 9th, just like we did some of the other ones. Do the assessment now and the penalties now, and then if they don't settle by April 9th, then they're on the hook for that.
Chair, I still have to read through the PowerPoint and show you the pictures, so can I continue?
Yeah, I'll cut into that, yeah. I jumped ahead of my little thing here, but go ahead.
The nuisance abatement hearing date was November 15th, 2017. The code violations, Chapter 34A, cultivation area is larger than authorized. In Chapter 34C, number of plants greater than authorized. The notice of the proposed lien was sent December 12th, 2017. The non-penalty cost to the county, $3,443.67, and the penalties were $21,000 with a total of $24,443.67. And as I stated earlier, the abatement date was October 25th, and there was approximately 100 plants. There was a residence on the parcel, and the grow was next to another set of hoop houses. Recommendation of the board is approve the proposed lien of $21,000 and a special assessment of $3,443.67.
Make a motion to approve the proposed lien of $21,000, special assessment of $3,443.67, given the opportunity to settle before April 9th.
We have a motion, do I have a second? Okay.
I can't second.
So it dies to a lack of a second. Do I have a different motion?
I'll tell you why. Look, they could have done this for months, and now to show up today, this is a little different. This guy's in business, I can tell. Make a motion to approve the proposed lien of $21,000 and a special assessment of $3,443.67.
Second.
Been moved and second. All those in favor?
Aye.
Any opposed? No. Okay. On to J, which we kind of know that's going to be the same thing, but I'll read it real fast. It's case number 17-1085. It's located at 349 Shady Oaks Drive, Bangor. AP number 028-340-039.
Code enforcement case number 17-1085. The nuisance abatement hearing date was November 2nd, 2017. The code violations, Chapter 34A, no legal residence, no cultivation allowed, cultivation area greater than authorized, grower residency requirements not met, and plants in public view, and no fencing or authorized material. In Chapter 34C, no legal residence, no cultivation allowed, number of plants is greater than allowed, grower residency requirements not met, plants are in public view, and no fencing or authorized material. The notice of the proposed lien was sent November 28, 2017. Non-penalty cost to the county, $3,633.89. Penalties, $26,500 for a total of $30,133.89. These actually were pictures from the ground. We didn't get any from the helicopter. Recommended board actions approve the proposed lien of $26,500 and a special assessment of $3,633.89. The abatement date on this one was October 18th, and there were around 99 plants.
Any questions of Chris? All right, would you like to speak on this one?
Charnel James of Marysville, California. For the landlord, again, we'd like to renew our request for a continuance in order for us to settle this issue. Like I had stated on the previous issue, we are working and have been working throughout the legal system the best that we can. We have a civil suit in process in order to make sure that we can recover those fees and get them paid to the county. So we can enter into the settlement agreement. We ask for time in order to take care of that. We prefer 30 days, but we would be willing to accept the September 9th date as well. Thank you.
Anybody else like to speak on this? Okay, seeing none, I'll close the public portion and bring it back to the wishes of the board.
Make a motion to approve the proposed lien of $26,500, special assessment of $3,633.89, that give him until April 9th to settle.
Second.
Been moved and second. All's in favor?
Aye.
Aye.
Opposed? Seeing none? Okay.
So that one passed?
Passed. Okay, next up is letter K, case number 17-0909, located at 7760 Old Huncut Road, Palermo, AP number 027-210-007.
The nuisance abatement hearing date was October 31st, 2017. The code violations was cultivation area too large for the parcel, no fencing or unapproved fencing materials. They were allowed around 100 square feet, and the cultivation area was 81 plants, around 8,200 square feet. The notice of the proposed lien was sent December 14th, 2017.
Oh, my God.
The non-penalty cost to the county, $2,841.27. Penalties, $47,500 for a total of $46,341.27. Here are the photographs. A very large fence placed around the grow, and there is a residence on the parcel. The abatement date was October 25th, 2017. Recommendation to the board is approve the proposed lien of $43,500 and a special assessment of $2,841.27.
Okay, any questions of Chris at this point? Okay, I do have a card. Betsy? Yes, ma'am.
Hi. Good morning. So the growers were not allowed to be on there. They were actually squatting. It was his father's house. He died the year before, and the whole time we were going through probate. My mom was awarded probate last month. We finally got the papers this month, and since that has happened, we have already started the eviction notice starting this month.
We had no rights, basically, because I wasn't appointed the administrator. So, and during that time, he was on probation. I went to probation and told them they didn't do anything about it. I mean, and our hands were just tied.
And he also tried to put a restraining order on my mom from even being at the property. So he was trying everything to keep us away. And we were actually ones who called the nuisance because we don't want this to be happening. So we're just asking that you guys don't approve it and give us time to get him out and get everything settled.
He's probably starting again. I don't even know, but we've just been helpless.
So we're just really trying to go the legal way, and we have done the eviction. He has 60 days. We served him with the 60-day notice since he's been there over a year.
It's kind of relative?
Yes.
He's a half-brother. My father didn't have a will, but he's been fighting me the whole, way. It's just the principle. That's why we called. The whole thing was just wrong. And he harvested, or whatever they call it, did the whole thing. So he's the one that's in the good, and then now my dad's property is.
So we shouldn't be penalized for something we had no control over, and we were actually really going through.
He didn't have anything. They basically took over everything. I mean, they cleared out his accounts.
So
everything. It's just bad.
The question is, who now inherits the property?
She is the executive administrator of the property.
So it's me, my brother, my sister, and then my half-brother.
But
he's done this whole thing.
We ran into this once before.
And we have no say-so. We couldn't do anything. I mean, we called these people and told them.
Because we don't want it like that either.
Okay, so legal counsel, help me out here. We did this once before.
Yeah, I'm just trying to figure out what was presented at the hearing.
The owner did have an attorney present, so there was a representative of the estate, and.
But how if he was deceased?
Oh, no, yeah.
Well, there was.
I requested that guy too.
Okay, so there was an attorney present at the hearing. That was the only individual there on behalf of the owner or any interested party. But the case was, very easy to prove up, so they didn't have anything to offer other than the owners were deceased. But there was still notice provided consistent with our process based on how the property is registered with the tax assessor's office. So if the property hasn't gone through probate or the tax assessor's office hasn't been updated to indicate that the owner's deceased, we just go off of what's indicated through their information.
I had requested that guy also. I was trying everything I could, to try to stop everything.
So would that be a civil thing then, as far as among siblings? I'm not an attorney, so I don't know. Would that mean as far as, if you had a brother or sister that was doing something wrong in your partnership or whatever, I mean, that's, how do we don't know that.
But it wasn't a partnership.
No, but you're a property owner, in a sense you are now, unfortunately, that property
But
together.
this happened before becoming the property
I brought
owner.
my thing, I just was awarded last month, so.
Fortunately,
Not knowing anything about the probate proceedings and what could have been done and whether there was counsel and what her rights were earlier, I really don't know what to say about that.
No. It's how you unfortunately inherited an encumbered piece of property. I mean, unfortunately, but I mean, that's not there yet, but I mean, that's a sad situation.
The whole thing, too, is he had no right even to be there. I mean, none. He didn't have permission or anything, and he had more rights than us.
And we did speak to the sheriff about our rights to even be there, and he suggested to us that we go through the legal way and for probate.
Is he a heir under the law?
Well, yeah, he's
There's
we got
four,
the same father.
there's 4 kids, and he is the only one that is not complying with the rest of the 3. So majority rules that he won't be able to do anything with the property because.
No, I get it, but under intestate laws, sounds like he's an heir. He's going to, like, say he sold this property or whatever else.
He was trying to sell it already, I guess.
Yeah, but what I'm saying is, he is probably going to inherit some money. If we assess this fine, that could come out of his share, and he could get a lot less.
Yeah.
So.
I understand.
But
that
it's
part,
not
too.
appraised for that much, so.
Well, I think this is a unique enough example that the decedent passed away before we noticed the property.
Well, we called them and told them.
Okay, you turned it in. I think that shows that
Try to do the right
you
thing.
took the step, yeah, the right thing is a good call. So technically, whoever showed up at that hearing had no right to represent the owner because they weren't the owner and they weren't appointed by the court. We weren't there at the hearing, but I think there's enough evidence for me that this couldn't be turned into an abuse. I doubt we're going to get a lot of people showing up, yeah, the guy died, we were growing marijuana, and that's the loophole that starts to be created. So we'll see what my other board members think of this unique situation. I'm going to make a motion that we don't approve.
Let's close public portion.
Oh, yeah, we got to close it. Thank you. If anyone else, so.
Thank you. Anybody else like to speak? Okay, nobody else wants to speak. We will close this portion of it.
Well, I think we can't let the guy off. I mean, so
That's where we need to be smart about this.
Yeah, what we've done in the past is that when there was 50% ownership, we only liened the half that the inheritant was wrong.
25%.
So what if we did 25% of the fine and they can go after him? Can we do that?
I think that's
Can
what we need
lower
to
it?
talk about, that this is unique enough that a little more brain power on this. Bruce, what do you got?
You have the discretion to assess whatever part of the proposed lien or the special assessment you want or feel is just under the circumstances, again, without knowing what the estate consists of and how much the apparent relative who abused the property would inherit. I don't know what percentage would be adequate or fair. You're sort of speculating a little bit. The lien does go against the property, no, not the individual. So I don't know how we would, make that enforceable through the probate against the individual. I'm just trying to think it through.
I think, Bruce, in my mind, that's up to them. We apply what we think is a fair amount with the limited resources we have. I don't want to get into their probate either. And let's just play this out. They sell the property, then they can fight it out.
I'm sure within the probate
But we
court-
can't give them a pass. I mean, the guy grew $100,000 worth of plants there. You know what I mean?
Yeah, no, I understand it's a difficult and somewhat unusual situation, but again, the board has the discretion I just don't see how we can do anything else other than approve all or a portion of the lien. We really can't get involved in what will or will not happen in the probate
No,
proceeding.
definitely not.
Because we have no authority to do that.
Yeah. All right, so I think with that discussion,
Would you just talk about this a little bit? So I think the special assessment has to stay on. That's recovering our direct costs, and then maybe a quarter of the other. Would you be good with that? Make a motion that way?
that's what I was thinking.
All right.
Just make a motion for a quarter of what's up there on the board, the total.
You can do it that way, too.
Does that sound reasonable to you?
I'm good.
Enough to get a second?
I'll second that.
Okay.
Hear that number, 10,000?
Do we need to break it out into each?
That's for the proposed lien plus the cost. I think Mr. Snellings is saying a quarter of the $43,500 and then the whole amount of the cost since we incurred those costs.
Okay, I'm good with that.
I'll second that motion.
Is that clear? Okay. We got a motion and a second. All those in favor?
Aye.
Opposed?
And again, we don't want to punish the innocent. I mean, or he had no knowledge, so.
Yeah, don't invite him to Christmas. All right.
So good luck in concluding the probate.
Yeah, have fun.
Yeah. Next up is the letter L. Case number 17-0820, located at 2621 Ludlam Avenue in Palermo, AP number 027-300-082.
Okay. The nuisance abatement hearing date, September 21st, 2017. Code violations, Chapter 34A, cultivation area greater than authorized. Grower residency requirements not met. In Chapter 34C, number of plants is more than authorized and grower residency requirements not met. The notice of the proposed lien sent October 24th, 2017. Non-penalty cost to county, $3,245.42. Penalties, $36,000 with a total of $39,245.42. This one did have a residency on it. As you can see, there was also fencing. Those are some pictures from the ground and from the air. The abatement date was October 11th, 2017, and there were around 99 plants. Recommendation of the board is approve the proposed lien of $36,000 and a special assessment of $3,245.42.
Okay.
I believe there was a request on this one to accept the settlement terms. This was the one where we needed the interpreter.
Okay.
So the interpreter came this morning, they worked it out, so I believe the request would be to approve the lien, hold it in abeyance until April 9th, and if they do what's needed under the settlement, then we won't record the lien.
Okay, so.
That's a correct reflect of what we're trying to do.
Great, thank you.
Great, thank you.
Anybody else like to speak on this one before I close it? Okay, seeing none, I think. Okay. Yeah, we're not seeing any. Okay,
Make a motion to approve the lien of $36,000 and a special assessment of $3,245.42 with the caveat that they have till April 9th to come in and make a settlement agreement.
okay, do I have a second?
Second.
Moved and second, all those in favor?
Aye.
Any opposed? Okay, thank you very much. Next up is M, which is case number 17-0577, located at 136 is that Schwing Loop, Orville, AP number 071-400-029.
Nuisance abatement hearing date, October 4th, 2017. Code violations, Chapter 34A, cultivation area too large for the parcel. Chapter 34C, number of plants greater than authorized. The notice of the proposed lien was sent November 21st, 2017. The non-penalty cost to the county, $4,134.15. Penalties, $57,000 for a total of $61,134.15. This parcel did have a residency on it. These are some aerial photographs.
Are those different types of plants, or is that not marijuana in some of those?
I believe they're just a different type. They're different strains.
Looks different, yeah.
And the way that they're
down the
pruned
corner.
and- Yeah.
They got some trellises kind of holding them up.
The abatement date on this parcel was October 3rd,
here.
and there are around 84 plants. Recommendation of the board, approve the proposed lien of $57,000 and a special assessment of $4,134.15.
Just to add on this particular case, Ms. James represented the owner. She did appear at the hearing. There was a stipulation reached that the owner received notice that the property was in violation and that the county was entitled to its costs and penalties. So there was a stipulation as to all three of those. So I believe that stipulation should still be in effect. I don't think there'll be any challenge to this, but I know Ms. James is here.
Okay. All right. With that, is there any questions at this point? Okay, I'll open it up to the public.
Charnel James, Marysville, representing the property owner on this case. We actually were willing to enter into this settlement. I was kind of surprised when I talked to Mr. Jellison that he hadn't been in there. I thought he would be here today, but he's not here. If we could pass it and give us till the 9th, I can get my client in to sign and do the settlement and get his payment in.
See,
I know, I'm sorry.
should be working bad behavior.
I promise the ones on the 10th, I've already got some of them done, so you won't see me as much.
Well, it's not a problem seeing you. It's just a problem, there's a time to do things, and the day after is usually not the day to do that.
No, I agree, and like I said, I was kind of surprised because he had, this property owner was very willing to work with the county and to take care of the issue, and I've called and left a couple messages and haven't been able to get hold of him, so I'm just, when you pass it, I'm just asking to give him till the 9th to get in there.
Okay.
If he doesn't show up and doesn't answer my calls, then that's on him.
All right, thank you.
Thank you.
Anybody else like to speak? All right, seeing none, bring it back to the board's wishes.
I'll make a motion to approve the amount of $57,000 in penalties and $4,134.15 for cost recovery, and allow them to wait until April 9th to settle.
Second.
Okay, we got a second. All those in favor?
Aye.
Aye.
Any opposed? You earned your keep on that one. Tell me he's lucky. Letter N has been taken care of, so we'll move down to the letter O, which is case number 17-1096. It's located at Single Lane, Berry Creek, AP number 062-760-004.
The nuisance abatement hearing date was November 14th, 2018. I'm sorry, that should say 2017. Code violations, Chapter 34A, no legal residence, no cultivation allowed, cultivation area too large for the parcel size. Chapter 34C, no legal residence, no cultivation allowed, and cultivation may only take place indoors on parcels less than 5 acres. The notice of the proposed lien was sent January 2nd of 2018. The non-penalty cost to the county, $3,336.53, and the penalties is $25,000 for a total of $28,336.53. These are pictures from the ground. There, I believe, is some type of bird netting over them. This was, abatement date was October 25th, 2017, and there were around 43 plants on the parcel. Recommendation of the board, approve the proposed lien of $25,000 and a special assessment of $3,336.53.
Okay. Any questions of staff? All right, anybody in the audience like to speak on this one? Anybody? Okay, we'll close that portion of it and bring it back to the board for more discussion or a motion.
Make a motion to approve the proposed lien of $25,000, special assessment $3,336.53.
Second. Got a second? All those in favor?
Aye.
Opposed? Okay, seeing none. That concludes that fun event.
I gotta ask a question. I mean, we sit up here and don't they think this is real? I mean, I don't get it. I just don't get it. If you come out, you hit the lottery, right? You get caught, and we tell you you can evade, and it won't cost you anything. Does anybody have an answer as to why? they keep doing it?
I believe, like you said, Supervisor Connolly, it's a business risk. They'd rather harvest and collect that illegal cash, and if the property gets sold at a later date, they've made a large profit anyway. It's a business decision.
Well, why would they accrue all these penalties when that's...
And the
what doesn't
property
make
with no
sense?
residents on it, they know we're coming back. I mean,
Yeah.
Well, I think unfortunately during the time we're out there doing this and they're getting close to harvest, that last couple of weeks before they pull them is when the plants fully mature and become that kind of quality they want to sell, and it's worth it to them. $1,000 a day
Yeah.
probably is not much compared to the extra money they're going to make to have that plant come to maturity, total maturity.
Some of them have been noticed like in October and November when it's really the end of the season. Those are the ones that don't make sense.
Well, that's just a timing issue, unfortunately. Yeah.
Well,
You know, when we get the complaint, we act, and unfortunately, if the complaint is later in the year, we run into that problem where, yeah, they've harvested, but we still need to enforce our program, and someday, hopefully, we recover on all these when these properties eventually are sold. And the settlements are a good thing, because then if people do comply with the settlement, that's sure money coming into us, and
Yeah,
it's
that's-
sooner than waiting for the property to be sold in another, who knows, 5, 10, 15 years.
there's another point. The public needs to be made fully aware. If you take a risk for a cash lease for a year, what do you think's happening on your property? I mean, don't come in here and think that we don't know, that you know, that you're leasing to somebody that's going to grow. And they're not going to grow legally. They're not going to pay you so much a month up front to grow for their personal needs, which brings up one more point that's evident to me. The majority of the people in Butte County voted that we don't care if you smoke a little weed. The majority voted that way. But they didn't vote that you can go out and desecrate the land and grow out of the box and more plants than is allowed by our law. That is not what was voted on. I hear that from people all the time. So I don't know how we get the message out there, but doesn't it strike the rest of the board? It's just ridiculous. You know, it just is.
yeah.
Well,
Why not?
I think,
I still have a question, though.
okay.
So we let all these other people go until April 9th, but we didn't let the property owner in I and J, I think it's I and J. I don't understand why we did some and not others, so.
I don't want to explain myself.
Yeah,
Well-
I think frankly that those hearings are over, and unless you're going to reopen them, I wouldn't get into discussion about why you voted a certain way on anything. All the votes were appropriate, the reasons were appropriate. If board members exercise their discretion differently, I think that's their prerogative, and frankly, I'd rather not have that particularly on the record.
Okay, well, I just heard you say it's better to try to settle than to wait till the property sells.
Well, we tried to settle. That's the thing. We get to this point, they've tried to settle. We've tried to settle up before this point. Now we get to this point, it's like, it's D-Day. So,
Yeah, and just to be clear, where people came in and their reasons for being here today asking for settlement covered a variety of reasons and a variety of factors. And if the board felt it was appropriate in one instance, then that's what the board did. If they didn't think it was appropriate in another instance for various factors, then that's what they did. I was just commenting as a general rule, if people are going to come in generally and settle, and the board thinks they're coming in good faith, then there's a value to that. It doesn't mean the board has to accept every opportunity to settle a case. If you think there are other factors or other reasons why you want to proceed with the lien and not with any sort of stipulation or agreement that if you settle by a certain date, we won't impose the lien. But remember, all these settlements don't end up successfully, and we end up imposing the lien anyway.
Yeah,
yeah, I just think it'd be nice if we didn't have to do this. We spend our energy and time on doing some more positive stuff for the county instead of regressive stuff like that. I think it's important. So moving on with that discussion, we've done that. I do have